and you go, and it just scrolls down to the bottom. You click, I'm good. I need to get this going. How enforceable are those? Are those enforceable? Or are they, because you're not actually given the chance to negotiate them. You just click yes. Are we ready to talk about law? And you're probably going, click, I'm going to go to the next video. But that's not how you should be, because when we look at legal elements within your business, this is probably one of the things most people only think about when they're actually in the situation of, crap, I'm now involved in a lawsuit, or I've got somebody who's not paying me, or I've got a challenge that are happening with my business that I need to go up and grab a paralegal or grab a lawyer. And at that point, it's probably already gone too far. Now, we know here you're going to be able to answer that probably and turn it into an actually situation. We've got Shannika here of Tailored Litigation, and I want to thank you very much for, number one, is investing your time here today, and number two, giving us 5 clauses. That's right, guys. We're going to walk away from this podcast having 5 clauses that you could put into your business today, obviously with legal advice. But you can put these into your day and just at least look at your contract, pull it out as you're listening to this contract and say, do I have these clauses in? If I don't, I need to give Shaneka a call. So first of all, thank you very much for joining us today.
Oh, you're welcome, Steve. Thanks for having
You
me.
know, as a person who has been in business, self-employed since 2007, I know that being in owning a business, it's not a matter of when you're going to be involved or if you're going to be involved in a legal problem, it's when. The longer you go into business, the bigger you get, legal things are going to come up. What do you find as when people reach out to you? Are they generally, it's responsive to a problem, or are they generally trying to be proactive?
I would say 9 times out of 10, it's people responding to an issue that has arisen.
And why do you think that is? I mean, when we look at insurance, we go out and everybody drives a car and everybody has an insurance policy. Why do we not take that same sort of mentality when it comes to law?
People really don't want to just pay the money, really. They think, having a lawyer review something or give them advice is too expensive, and they don't want to have to worry about something that may never be an issue.
And how many times does it actually become an issue when you look at businesses? And is it because they've been in business long enough? Is there specific industries that find themselves more in tune with having these types of problems?
I think really no industry is immune. I think it really just depends on how good of a business person you are, how well oiled your business is. If you've taken the proactive steps of putting in proper policies and procedures and systems in place before. And as you said, as businesses scale, problems arise, right? What's the old adage? More money, more problems.
I love it. I love it. More money, more legal. And so say you've got that candle shop or that, towing company out there, and, they get their first tow truck. And, a lot of times when you think back to the day when people would buy something, you get that little receipt on a piece of paper. It's kind of scrawled, or, you give them cash and the deal's done. You know, when is the time to start thinking about?
The time is from the very beginning, right? From the time you have the business concept, you want to make sure that you're getting yourselves in front of a business lawyer that can help you navigate what business structure do I need? What agreements do I need to have in place? What terms and conditions do I need to have in my service contracts with my suppliers, my contractors, my employees? So all of that you should be brainstorming with your business lawyer at the time that you're thinking of going into business
And
before you even open the doors.
so I think it's great that you kind of listed some of the people that you need to consider, because most people don't think about, I need to have it with my vendors and, that sort of thing. So let's go through that list again of when you're looking at getting in a relationship with somebody, who are those key players that you need to think about having good contract?
Well, certainly you're going to have contracts with your employees, whether they're employees or independent contractors. You're going to need are going to have people in your business to provide the service that you're offering or the product that you're offering. So then you're also going to have suppliers. So whether it's suppliers of raw materials or even just suppliers to help you run your business, software providers. So you're going to have suppliers in your business. And then you're going to have people who you sell your service or product to. Those are your customers or your clients. So those really are, I'd say, the top 3 buckets of individuals that I can think of that you would be dealing with as a business owner.
And I think those are great buckets. And I think when we look at these five key essential clauses, and I think the last one probably being one of the most important one is when we look at these clauses that we're going to break out today, the first one obviously is payments. How does money move? And first of all, when we look at those different clauses, cash flow is so key for a business. And I know a lot of times you put out an invoice and you're crossing your fingers, hoping that's going to get paid, and and then it doesn't. And I think a lot of times when people put together their, net 30 or 2% 10 net 30 kind of contracts or whatever they put in, they kind of put that as a little line item in the invoice, but there's no meat behind it. What are some of the things that people need to consider when putting in a payment clause?
You're absolutely right. Like cash flow is king. It's the oxygen of your business. And when we're talking about payment terms, that is the lungs. That's the way that you get your business the cash flow that it needs. And so what's really important when you're talking about payment terms is you want to make sure that you're specifying in your contract when is payment due? Like when is the payment due date? What amount is due? What is the acceptable payment methods that you want to implement? Will there be fines for late payment? Will there be an interest rate that is charged, right? So you have to make sure that you're considering all these things and implementing those. So when you have on your invoice, net 30 days, 2% interest, you really want to spell it out for people so that they understand, okay, well, what does that mean? Right? So making sure, so for example, if you want to put in your contract, client agrees to pay me total of X payable by Y date, and a late fee of 2% would apply per month until payment is due or payment is paid or made in full.
Now, a lot of generally people will put that sort of level of detail into their contract saying that, this is the date that it's due. It might be 15 days after the invoice has been put out. And if that payment is not made, a 2% interest fee per month will be due on that invoice. And and then they'll put the little descriptive then there'll be the last page that has the clauses, and it'll say things like, and whereas this there shall be thou doneth thy, and it sort of sounds like either the first chapter of the Bible or their legal ish that they want to put in. and
Yeah.
and how much of that type of clauses do you see that are completely and utterly unenforceable?
Yeah, you really don't have to put in all that legal ease, we call it, language in your contract. You want to make it as um, easy to understand as possible. And even as lawyers, we are retraining ourselves to draft our contracts to make it as easy as possible for someone to understand. And to your point, it's not so much, when you're starting we call a recital being the first part of a clause. It's not so much when you're starting with whereas, blah, 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 blah. It's do the words that then follow make sense, right? Because that's what contract enforceability is all about. Do the parties that are signing the contract understand what it is that they sign? And if you bring it to a lawyer and they can't make heads and tails as to what you're saying, then that's a huge problem because if they can't make heads and tails of what you're saying, a judge is not going to understand what you're saying. And if the judge doesn't understand, then the judge is going to say, well, clearly, if I don't understand, you guys as parties to this contract didn't understand what you were agreeing to. So therefore, the contract's not enforceable or that particular clause is not enforceable.
And I want to, you mentioned the word judge, and each time that I've ever gone to court, it really never ever got to that point. I mean, I had one lawsuit that went over 10 years, and it always seemed that it's not who's right or wrong, it's what you're prepared to settle for. Is that a truism, or is that, somebody misinterpreting the legal system?
You know what? It's not too far off from the truth because if you think of lawsuits in Ontario, our court system is so backed up that it takes years for anything to get to a trial, which is why most cases settle before they even get to a trial. That coupled with the fact that really most cases should settle before we go to trial, but it just takes so long. And I always say like the best settlements are where everyone is a bit unhappy with the outcome because that means that you've come to a compromise that everyone can live with, right? Nobody wants to come out of a settlement thinking they gave away the whole house
Yep.
and got nothing in return, right? Everyone wants to feel like, okay, I gave up on something later, but I got this in return. So as long as the parties can, with heads, cool heads always prevail, come to a resolution that works, I always think that's a better scenario than spending thousands of dollars on legal fees to resolve your dispute. Because at the end of the day, when you go to trial, there's only one winner. So it's all or nothing. And you want to make sure if you're taking that risk, you're getting the all versus the nothing.
And how often do you see when you say, again, we talk about settlement, and I know this is a little bit of a deviation on payment, but that's where people really are trying to, capture the money that they've lost in the process. When it goes to trial, how often, number one, how big does the amount have to be to go to trial? And then number two is how often is the person who is going after the money actually collecting the money?
Yeah, so it really depends. For the first question, it really depends on which court that you're in, right? If you are bringing a lawsuit for a claim that is under, I think it's 25,000, that's small claims court territory. And so depending on if you're doing that on your own or if you have a paralegal or a lawyer involved, I think the cost benefit analysis, you really have to run to see, okay, does this make sense for me to push it to trial? And if I do get to trial and I am successful, that is just the first hurdle, my friend. The second hurdle is collection. And that's where it gets serious because yes, as a lawyer, I may be able to get you a judgment, which is a piece of paper that says you're entitled to X amount of dollars. But if you can't collect on that judgment, you're left holding a piece of paper that says somebody owes you something.
Yeah. Yeah. Which you had
And
that
so,
anyways, just emotionally, but now you got it physically.
but you
And
have that. And there are mechanisms that you can, put into play to get the monies that's owed to you, but that itself could also take time and certainly expenses.
yeah, and I know you're well quoted, and I don't want to spend too much time on the real estate side, but I know in, where builders right now are going through a massive amount of people not performing against their real estate contract to buy the properties that they've committed to doing. And builders have to go out and not only get the judgments, but then enforce. Do you find a play in that space, either personally or adjacent, where builders are really, having to go out and double check, is it worth chasing this person down, and what's the percentage of them that are, and if so, are they actually getting performance?
So I get asked this question quite a bit, and I'll have clients come to me and say, well, I read on Facebook or I read on so and so that the builder is not really going to sue me, right? Really? And I always tell them, so you're going to be that special one that they don't sue? Really?
Yeah, that's right.
Particularly in this economy where people are walking away from agreements of purchase and sale left, right, and center, like the builders are really struggling themselves, right? They're taking hardline positions and bringing these claims and getting judgments. Because if you think that a judgment, particularly in Ontario, once you have a judgment, that's good. Like your judgment is good until it's paid. And you can register that judgment in the form of a writ, and that writ is good for 6 years, and then you can renew it for 6 year periods. So, if I'm a builder or someone who has a lot of patience, I can sit there on that judgment and wait until you get into a better position in life and then pursue you for that money.
And if they did a bankruptcy, does that preclude them from that judgment, or does that supersede?
That's an exception, yes. So that a bankruptcy does, in certain instances, will wipe away a judgment, but there are exceptions. There's an exception to every exception. There are exceptions where, even though a person does file for bankruptcy, that a judgment can survive if it had certain provisions in it before they file for bankruptcy. But
Interesting.
you, but you know whose debt never gets wiped away?
To see the R and the A.
The CRA, my friend. And I
Yep.
shouldn't say never, 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 but they know how
Never
to
ever
get their
ever.
money. They know how to get their money, so you should know how to get your money too.
Well, that's exactly right, and that's where I think knowing that you have a good contract around payments and getting that advice, because there's going to be a moment where you're going to need to do that. Now, if you're somebody who, your average contract size is, say, a few $1,000s or a few $100s and that sort of thing, you know, where does it become super important to put in any sort of extra clauses? Because again, it goes down to enforcement, and are you got to just play the Russian roulette game.
So I think that's where it's even more important to have your clauses right and tight from the very beginning, because the less interpretation that has to go into the clause, the less problems you have.
That makes
And
total
so,
sense.
yeah, if you have a clause that is clear on its face what the party's obligations are, like there really is no fight. And if you have to go to court, then it's straightforward.
Yep. Yep. Yeah, and that totally makes sense. Now, moving from payments into, let's just say, everything is great until it isn't. And one of the sweet three-letter acronyms that we love is MRR. There's frankincense, gold, but MRR is the most valuable because that's monthly recurring revenue. And so when we talk about contract terms and contract renewals, and you have this monthly renewal or annual renewed contract, what are some of the things that people make a big mistake on when they look at contract renewal?
Yeah, so most businesses don't really think about, the length of their contracts. And some of them will unknowingly get locked into unfavorable automatic renewals, right? So you have to make sure that when you're negotiating your contract, you're paying specific attention to the term and the renewal clause. When does the contract start? When does it end? Is there something in the contract that says it auto renews? And if it does, how long does the auto renewal go for? Right? And is there an option for you to opt out of auto renewal or provide notice that, listen, this isn't working out for me anymore. I want to be able to cancel when I want to be able to cancel. So that's really important that you look into those clauses carefully.
So, I mean, we've all been party to these situations. Well, maybe not all of us, but let's just say some of our listeners have, where you sign for that contract for that piece of software and it's cheap for year one and you're like, oh, it's great. But then they have this auto renew clause a year later and it auto renews for some stupid amount. But you don't, it's a year later. You kind of forget about it. And it's a piece of software that you just stopped using. You never decided to go and you didn't hit their cancellation button that's buried somewhere deep inside their website. And then bam, you get smacked with, that $2,000 or $3,000 auto renew that you went, whoa, hold on a second. I don't even know who you are. And, they didn't give any forewarning around that. Is somewhere where they do a situation like that. Is that something that's enforceable or is that something that you should be able to get out of, or how does that get structured?
It's definitely enforceable because that's what you agreed to, right? Which is why it's super important to read these things carefully and to the extent that you can negotiate these things. Negotiate the auto renewal, negotiate whether or not they need to provide you
With a notification around the idea that that's coming up, because if they don't do that, then they're not holding up their end of the bargain.
and also negotiate how much notice they need to provide you. Sorry. And one thing that I learned the hard way, and which I tell my clients now to do, and which I also do, is put a reminder in my calendar from the day that I signed a contract.
Well, then, as that comes up, a week or two before, hey, am I still using this? And if so, do I want this auto renewal to happen? That makes total sense. I know there's a signing software that I use that only builds annually. And year after year, I'm thinking, I got to get away from the software. But then the renewal date hits and you're like, it's already renewed. I guess I'll keep it for another year
Yep,
without, yeah. And so by putting that in as a month or two in advance, and then a month in advance, and then a week in advance, then you're thinking, okay, now I can actually take this renewal or offboarding seriously.
exactly. Exactly. And one of the things that I do is, and I actually just did it today, is when whenever you sign up for these free trials, make sure you know where to go to cancel, put that in the calendar, and make sure that you're activating it, right? Put the actual link in your calendar. Okay, go here to cancel this subscription if I no longer.
Now, if you're the vendor and you're the one sitting on the opposite side and you've given them the disclosures that, hey, this is a monthly renewal, this is something that you're going to have to pay. And then they claim ignorance around those things. How can you protect yourself as the vendor?
Well, you always want to make sure, if possible, that at the beginning of the contract, you're going through it or having someone go through it with the client, right?
Mhm.
And saying, okay, is there anything in here that's not clear to you that you want clarification on? And to the extent that you can, record it, like with mutual consent, and so that when they come back in the future and say, hey, I didn't agree to this or didn't sign up for this, you have something that you can fall back on, right? Or even if you put at the end of the contract when you're signing, I agree that I've reviewed all the terms and conditions of this contract. I understand it. I had an opportunity to get legal advice if necessary. Just put it in extra steps for yourself to make sure that you're protected.
And do you need a cooling off period in contracts built in, or is it, can you have it generally accepted if you go through that? That's not required.
That's generally not required. There are certain types of contracts in Ontario that require cooling off period. One example is in a new build space, but you don't generally need to. You can certainly offer one if it makes sense for your business model, but it's not a requirement.
And so if you did do that, would that create a better sense of performance against giving, upfront notice to say that, hey, we've given you full disclosures, we've given you full chance, you've now signed into this, we gave you a cooling off period, you didn't exercise any of that. And
Yeah,
so we're pretty much locked and loaded.
I think so. I think, and if I think about it some more, I think generally that's what these, 1 week trials are meant to do, give you that cooling off period. Hey, I tested it out. I see how it worked. I'm good to go.
Okay, that's good. And so if we look, number one, we've looked at payments as the first one. We've looked at contract renewals. That's the second one. The next thing that I think a lot of people really don't spend a lot of time on is what happens when we don't agree. What's a good dispute resolution thing that people need to think about that most people don't?
Yeah. So when you're going into your contract, you really want to think about how do I want my disputes, if it ever should arise, to be dealt with, right? And there, in Ontario at least, there are generally three mechanisms whereby you can have a dispute resolved: mediation, arbitration, or litigation. And so, depending on the type of business that you have, so let's say, you have a business where privacy and secrecy of your product is really important to you, then you may want to consider mediation and arbitration versus litigation. Because mediation and arbitration, those are private processes. Those are private processes where in mediation, you meet with a neutral third party, the mediator, who helps to facilitate dialogue between the parties and help them reach a settlement. They don't make the decision for you and they don't force you to settle, but they help you to come to a compromise. And arbitration, similar, where you have a neutral third party involved who acts as a judge in that case. And they hear the evidence, they hear the arguments from both sides, and then they make a decision that is binding on the dispute. But the thing with arbitration, it's a private process, right? So it doesn't get reported publicly. No one will ever know about it unless the parties agree to share the terms of that decision. Whereas with litigation, that's more the traditional legal process where disputes are resolved in court, right? So again, in front of a judge, possibly a jury, you follow formal procedures, formal rules of evidence, but everything is in the public record. And so you or I can go look that up, the decision following a lawsuit, if we want to know, what happened in a particular case. So
That makes total sense.
those are the things that you want to think about when you're getting into dispute resolution. And also with mediation and arbitration, those tend to be less costly than litigation, and the process tend to be faster than litigation.
Did you ever, in mediation makes sense because that person is, trying to find the ground that everybody settles on. Arbitration, do you ever find the focus really becomes on who is the arbitrator? And, who is the person who is actually going to make the decision? Or do you find that they just mutually come together on picking that fairly quickly?
So that's also one of the things that you can put in your contract, right? You can put in that the parties can either assign one arbitrator or each person gets to pick an arbitrator, and then those two arbitrators pick a neutral third person. So it's almost like a panel, right?
Okay. Yeah.
Yeah.
Can your contract stipulate who the arbitrator is? Or would that be considered as not a good way to do things?
I wouldn't necessarily do that because let's say, your dispute arises many years in the future. What if that arbitrator retires or dies or just doesn't want to arbitrate your dispute? Then you're left with a clause that's not enforceable, and that's not what you want.
Could you have it that you have the sole and absolute right to pick the arbitrator in your contract?
Yeah, you could, but why would the other side agree to that?
I don't know. I'm just
Okay.
asking questions.
Listen,
I've watched my episode of Suits, and I know Harvey Specter. I'm just trying to figure
hey,
this out. I'm Mike is
yeah, hey, you can ask for the sun, the moon, and the stars. Whether you'll get it is a different story.
and and when you look at some of the ones that we've talked about, and either and some of the other ones we're going to go into, know agreements. When we look at the next one is the entire agreement clause, and let's just kind of hit what that means. And then I want to kind of go into like what's the worst you've seen in some of these instances as sort of a middle ground. So the
Yeah,
entire agreement clause, let's first describe what that is and why that's important.
yeah. So an entire agreement clause is essentially a clause that says, no matter what we talked about before we signed this contract, no matter what promises I made to you or you made to me, or no matter what we discussed before the contract, none of that matters unless it is all in the four corners of the contract. So, for example, if I said to you, I'm going to give you a 50% discount on your first month of services, and that's not in the contract itself, the entire agreement clause precludes me from going after you for that discount because it's not in the agreement. So, i.e., the entire agreement. So, the entire agreement clause essentially says that this contract is the entire agreement between us, and nothing else that was said or done, if it's not captured in this document, matters. So it's really important that if you discuss something with the other party that you think is really important and you want included in the contract, it has to be there. Otherwise, you can't rely on it later on.
So in those situations where the entire agreement clause does exist within the contract, and somebody emails says, "Hey, we're going to do this," but then it actually never makes it into the contract, does the entire agreement clause wipe that out, or is it there's provisions that's not necessarily the case?
So generally speaking, most contracts, I'd say 9 out of 10, will have an entire agreement clause because it's one of those boilerplate clauses that is in every contract. So again, if whatever it is that you're asking for didn't somehow make its way into the contract, you can't rely on it if there is an entire agreement clause. If there isn't an entire agreement clause in the contract, then yeah, you can rely on pre-contractual representations is what we call them.
And so what does that describe to me, though, what that means?
So all the things that we talked about before, all the promises that we made before, all the inducements, you told me, okay, you're going to give me 50% off if I enter into this contract, but you forgot to include it. If there is no entire agreement clause, then I can rely on, oh, you remember so and so told me that I was going to get a discount? Yeah, I never made the contract, but here I have that email where you said you were going to give it to me. So I can rely on that email because the entire agreement clause is not there.
So let's think about a company that maybe didn't have agreements in place and now is trying to get some formal legal structure around the relationships they have. Would they use this as a way of saying that this is the, and for lack of a better term, this is the estoppel, this is the thing that supersedes every other discussion that we've had, and this is now our new arrangement, and the entire agreement clause kind of says that there's nothing before and there's nothing after. This is the moment. Is that what this one does?
Preci- Precisely. Precisely. If you've signed a contract that has that clause in it that says this supersedes everything else, then you're effectively agreeing to wipe everything else out that you've heard
Okay, so
or
this
said.
is when somebody's doing its cleanup time. This is a great way to say now this is our cleanup. Okay, that makes sense. And then now a lot of times what people will do is they're going to go out, and I just want to put this right in the middle because guys, this is really important. We just actually went through this as we were building up this podcast. Is the idea of, well, I'm just going to go to ChatGPT and build it out, and we know that I love AI and I'm a huge fan of it. And I think it has its place within a business. But when we put that into context of the legal environment, it can be very dangerous. And so talk to me a little bit about that. And what have you seen where people, again, it's like the legalese is we going to get legal AIs is that we have that happen. What's your thoughts around that and where have you seen that gone wrong?
Listen, Chat GPT, GPTs in general are a great tool. They are a wonderful tool as long as you're using them appropriately. And one of the things that happens in GPT, because it's a software that is developing, AI is still, fairly new, is it is learning as it goes. And one of the things that one of this AI wants to do is to give you an answer. It wants to make you happy. And so to the extent that something doesn't exist, what it tends to do is make things up and package it in a way that sounds good. So for example, there are cases where lawyers have gone to court and cited cases that they have found on ChatGPT that do not exist. And they've been sanctioned by the law societies because they just got lazy and just put in a scenario in ChatGPT. And, as I said, ChatGPT wants to make them happy. So it says, in so and so case, this is what happened. And rather than going to look up so and so case in the actual legal directories and repositories, the lawyer doesn't and just puts that in their brief. And then the other side, when they're doing their cross checking to find that case, sees that it doesn't exist. So you want to make sure that whatever GPT spits out to you, that you are fact checking and double checking the accuracy of that content.
Yeah, I think that's so important. And we actually did that as we were doing the podcast because there was a couple of things that I brought up and went, that doesn't exist. And I looked up and we went, no, in fact, it doesn't. And then a couple did. And so you never really know until you know. And I think that's really important to do that. And
if I can add one more thing, Steve, and a lot of what I'm finding a lot of clients are doing these days is using GPT to draft their contracts for them. Again, it is fine to use that as a starting place, but never as an ending place, right? Clients are trying to save a few bucks because they think, okay, I'll just put it in GPT and it will spit something out for me. Okay, if they do that, make sure you send it off to your lawyer to double check. Oftentimes, though, it's probably going to cost you more for the lawyer to redraft what you've come up with than to start it over. But I would say never rely on it as your final product. It's going to be your first draft for anything that you do.
yeah, and I know in real estate, we use a lot of pre-constructed clauses, where it comes to warranty statements and that sort of thing. In the litigation environment and in drafting commercial clauses for contracts, do you find that you rely on a lot on things like I remember I think it was Diane Durham had a lot of standard clauses, and do you find that pulling some of those becomes valuable and useful because they've actually seen the light of day in court versus kind of making them up as you go?
I definitely think using one of those types of software is always better because if you think that if we use the example of the array of forms, right, and the pre-printed clauses in those forms, all those forms and those clauses were created by lawyers,
Mm-hmm.
right? So hundreds of hours went into vetting the clauses, making sure that they're easy to understand, making sure that they are enforceable, right? And that they can be relied on by the masses. And they have been interpreted by the court since over time. And they're also being updated from time to time. So I think it's always a better approach to use those clauses or at least use them as a starting point than trying to come up with your own clauses on your own.
Yeah, that makes so much sense. And especially, it's just like I was talking with a tax lawyer talking about, it's great that you've saved money on your tax because you use this loophole. How many times has that loophole actually been audited by the CRA? And if you've never been audited by the CRA for that loophole, you're just going on a hope and a prayer. And only up until the time in which you get audited do you realize that it actually works. And that's the same thing when it comes to clauses, is if it's never seen the light of day of court, you never really know if it's truly going to hold water.
It's so true. It's so true.
Yeah. Yeah. Now, when we've obviously talked about renewals. Let's talk about the opposite of renewals, termination clauses. And termination clauses, the importance of putting those right. Where do people normally make mistakes on termination clauses?
So you want to make sure that you're thinking about all scenarios. It's great when you're getting started in business or getting started with a new contract. You're happy, you're hopeful, nothing is ever going to go wrong, but you have to plan for all eventualities. And termination clauses are just that, right? These are clauses you use to determine how and when a contract needs to be ended. And it's super critical that these clauses cover things for under what circumstances can the contract be terminated? Is it for a breach? Is it for a non-payment? Is it because you filed for bankruptcy, right? You want to make sure that you're setting out any penalties if there's a termination early, or how much notice that you have to give if you have to terminate. So I think those are the big things that you want to look at with those
when it comes to it.
clauses.
And is there something where you could say that a contract would be considered not enforceable if the termination clause was very one-sided in the way that it was generated? Or does it have to be balanced? Or can you orient, if as long as they accept it, it's good?
So courts have been really looking at the commercial reasonableness of contracts, right? So if you have a situation where the power imbalance between the parties is unbalanced, then the court is going to look more in favor of the party that is disadvantaged, right? So if, let's say, you have a termination clause that says, and that is drafted by the party that has more power, that says this contract can be terminated at any time by my will, and that doesn't really protect the weaker party, then those clauses are going to be more frowned upon by the court. So you want to make sure that the power dynamics are balanced, and to the extent that they're not, you have to compensate for that in the clauses that you're working with, particular determination clauses.
Now, I know there's a lot of software programs out there like Termly and all these other ones that come with some prepackaged clauses around these kind of conditions. Do you think that those software programs do a good job? And again, without being specific to the vendor, of kind of bringing some of these to light, or are they giving false sense of hope to the user?
I think it really depends on the software, to be quite honest. It depends on the software, it depends on the particular niche that the contract is dealing with. So, example, if it's an employment contract versus a supply contract, I think it really depends. There are some softwares that are geared towards particular subject areas. So, like, say, family law, right? And those are clauses that are used time and time again. We talked about the real estate scenario, and those clauses are used time and time again. So I think it really depends on the software. And again, it all goes back to first principle. Is the clause that is being disputed, is it fair and reasonable? And did the parties have an opportunity to negotiate the clause and to really turn their mind to the implications of the clause? And if you can prove those two things, then you're more likely to be successful than not.
So let's quickly hit on the negotiable, because I know we're coming up to the end of our podcast, but I want to hit this one because I think this is interesting. I mean, how many times do we go out and buy that piece of software, and then you have to click that "Do I agree to the terms and conditions" button, and you click the, in the middle of your mouse, there's that little scroll button wherever it is, and you go, and it just scrolls down to the bottom. You click, "I'm good. I need to get this going." How enforceable are those? Are those enforceable? Or are they, because you're not actually given the chance to negotiate them. You're just, you just click yes.
They are enforceable. You may not have an opportunity to negotiate, but you certainly have an opportunity not to sign it, right? And so you have to make sure that you're reading these clauses. And as case law has developed, there are certain things that has occurred in the past. So for example, there have been a number of cases where people have gone to ski chalets and ski resorts and injured themselves. And these ski resorts are notorious for having these waiver of liability clauses, right? Where it says, don't matter what happened to you, you could die, right? You are agreeing that you're never coming back to sue us. And the case law has developed over time where it says that, listen, if you're telling somebody that they're going to assume all risks to themselves for engaging in this activity, that has to be clearly spelled out in your contract. And so what would happen is, and what had developed over time is, these waiver of liability clauses would be in bold, would be in uppercase, would be in caps, right? Because they really want to make sure that is being brought to your attention rather than being buried in 10 pages of scrolling. And so, there are opportunities, I'm sure, to test the case law and see, okay, this end user agreement that I signed, can I really challenge this? Maybe, but do you have the time and the money to do that? Do you have time and the money to go against, these big corporations that have armies of lawyers behind them to try to challenge these clauses? Perhaps not, but you really have to, as I said, I think the dichotomy is, do you sign it and take the risk that you are agreeing and will be held liable to the terms, or do you just not sign it and
And not buy
not
it.
do and not bite. Exactly.
Yeah. And that's always the hardest thing because I think, a lot of times there's buried clauses around privacy, buried clauses
Hmm.
around how they're going to use your data, buried clauses around those types of things. And a lot of people don't realize these things that they're signing, whether it's the privacy policy or the terms and conditions, around that. And that's definitely a difficult one. The last one that we talked about, which I think is one of the most important, which is a dispute clause. And saying, how do we actually handle a dispute? I want to talk a little bit about that. What does that look like, and how would you tailor one around that for that small to medium sized business?
Yeah, so we kind of touched on it when we were talking about the three different types of the dispute resolution mechanism. So the mediation versus the
Yep.
arbitration versus the litigations. A standard clause that I would recommend people use and certainly expand upon for your particular business is, let's say you decide that, okay, given the nature of my business, given that I want to protect my product, given that I want to maintain confidentiality, I want any disputes arising from this contract to be dealt with by arbitration. So you could have a clause that said, for example, all disputes arising under this agreement will be resolved exclusively through binding arbitration, conducted in accordance with the laws of, and you put in whatever jurisdiction, and in accordance with, let's say, the ADR, the word is missing me, something dispute resolution mechanism, right? So you want to make sure that you're specifically spelling out what is the mechanism, i.e., arbitration, which rules will govern. So, for example, the rules or the laws of Ontario, and which arbitration rules will govern. So, the rules of ADR.
So when you look at the locations, so say for example, you're a business that does business all around the world, and you say, I want to go by the rules of Ontario. Is there anything where that could be considered that you couldn't uphold that because maybe you do a lot of business proportionally in Florida, and so that vendor or that customer would say, well, no, we're going to use my laws because I'm the one suing you.
If it's not in the contract or if it's in the contract.
If it's in the contract.
So that's the thing. Like, you want to negotiate which laws will govern. Because if you are an Ontario resident or an Ontario business and you are familiar with the law and let's say you're the supplier of this particular product, it makes really little sense for you to agree to be governed by the laws of Florida if you don't have a connection to Florida other than you're shipping your products to someone in Florida, right? So, and there's a whole area of law called forums non-convenient, where people argue about, is this really the appropriate forum for this dispute to be dealt with? And so you don't want to find yourself in that situation where you're fighting with someone over what laws should govern before you even get in the fight about the actual dispute. So
And
be
how many
really
times do you,
clear.
and how many times do you see when somebody's like, say they're getting into a franchise agreement and the franchisor is based in, I don't know, Delaware or something, and they said, we want to go by the laws of Delaware. And the franchisee says, no, I'm based in Ontario. And how many times do you find that franchisor would, acquiesce to a different jurisdiction, or do they generally just say, no, it's our way or the highway?
I think going back to what I talked about, the power imbalance, the party that tends to have more power will have more sway. So in that example where, the franchisor, they're using their standard franchise agreements that they use across all their franchises, they're generally speaking not gonna change important terms like the forum for every single franchisee, right? So that's probably one that you're not going to get changed. And so if you're not going to get it changed, you really have to make sure that you are aware of what the implications are. If you have to go get a lawyer in Delaware to explain the rules there to you, to go over the contract with you, and to make sure that, what they're saying is correct, then that's what you're going to have to do.
Because the one thing that I've learned in spending some time in the States is every state is very different in their local laws, and every jurisdiction within that state can be very different in their local laws. And so what happens in those situations is, I guess you really need to vet the location in which you're doing business with.
Absolutely. And it's the same thing in Canada. Every province has different rules and how they interpret their rules. So just because you are in Ontario and you're contracting with somebody in BC doesn't mean that they have the same rules that we have here in Ontario.
Yeah, that makes total sense. That makes total sense. Well, we could go on for days on talking about the different ways that people need to protect themselves. But I think what I've got as a major summary is you have to take your legal seriously, just like you take your tax seriously, just like you take your insurance seriously. Is if you're going to be doing business, understand that you are doing business. And part of that doing of business is looking at where the exposure exists within your business and the relationships that you have. And I think these 5 key elements that we've covered here, where we look at the, number one is having that ability to be able to look at payments. And number 2 is looking at saying with those payments, and I'm going to pull up my list here because I made a nice little slick list as we were talking here. And where is it?
Five power clauses,
Yeah, your
payment terms, contract terms and renewal clauses, entire agreement clauses, termination clauses, and dispute resolution.
Summarized beautifully. Now, Shannika, for them to get a hold of you, obviously, I think the easiest way for them to go through is find you at Tailored. That's Taylor with a D, litigation.ca. Is probably the easiest way to find it. You're all over different podcasts and stuff talking about real estate, but I really thank you for taking the time to talk about commercial litigation, because I think that's something that a lot of people really only see once it's too late.
Absolutely. Yeah, happy to chat with you, Steve. And people can also reach me by email at Shaneka at tailoredlitigation.ca. 416-628-9830 is my number. But yeah, you're right. Like, we're all over socials, and I think we're pretty easy to find.
I definitely think so. And that's why you speak on a lot of stages, because I think you do a great job of really sharing information to allow people to know where their exposures are so they know the right thing to do. So thank you very much.
Thank you.
And guys, this is the money, this is the mindset, this is the mentoring podcast. We'll see you on the next one.